Howdy, and welcome to the White Hat Law Show with Warren Nord, where we cover a mix of current events, politics, and the law. Take it away, Warren.
Welcome back to White Hat Law. I'm Warren Nord with Nord Law. We practice law in downtown Arlington. And today with me, we have Clayton Everett. Clayton is joining our organization to handle bankruptcy matters, most particularly. And Annette Nord, who's, besides my wife, is the managing paralegal and handles most of the bankruptcy matters in the office. Before we start in the process, I thought we'd talk about bankruptcy generally. People sometimes have some misconceptions about what bankruptcy is. Bankruptcy, in my mind, is a recalibration of a person's finances with the rest of the world. Somebody gets out of whack, beyond control on credit cards or student loans, or loses their job for a little while, and they just can't quite get back caught up until they get it fixed. We're also going to address different aspects of this. We're going to address the debtor side, so ordinary people, that file bankruptcy. We're talking about businesses. We'll just touch on that for a little bit, and then we'll talk about creditors. What happens if you find that somebody who owes you money has filed bankruptcy, and what to do there. Let's talk about drivers for a minute. If somebody's in a situation where they're beyond control and they say, I need help, so they go to the internet and they put in their first search engine, attorney, bankruptcy, or financial concerns, or credit counseling, something like that. It could be student loans. It could be a lost job. It could be a foreclosure on a house. It could be a payday loan that's no longer controllable. What else do you guys see?
Taxes sometimes, medical bills.
Taxes, medical bills.
And then lawsuits and judgments often.
You've been sued, and you can't afford to have an attorney, and you know it's not going to go your way because something's gone the wrong way. Now, not everything winds up being a bankruptcy. Sometimes people come in, pretty common. A bankruptcy doesn't always help you with an IRS matter. It may not help you with a student loan matter. We just have to actually look at what's going on. Sometimes it can. So we have to look at these things individually to see if that's going to be the right thing or not. Let's talk about how to pick a bankruptcy attorney. Of course, this is a little bit self-serving. I want you to pick me, but you may not be anywhere close to us. You want to pick a bankruptcy attorney that can give you some personal attention. If you get a piece of paper from a bankruptcy attorney that says, sign this document, and then whenever you want to get information from me, you're going to send me an email, and then sometime in the next few days, I'll send you a response back. It's probably not what you want. Now, at the same time, you shouldn't expect that you're going to get minute-by-minute response from a bankruptcy attorney, but it is still an attorney, and you're going to have a long-term relationship with this person. If you're filing a Chapter 13, you're going to be married to this firm for 3 to 5 years if things go right. So you really want to take the time to visit with 2 or 3 attorneys. Some people will ask for money to talk to you. Some people won't. So, but it's important to be comfortable and don't let yourself be rushed into this.
A few other things you might want to look for too is what kind of organizations that the attorney's involved in. Are they part of the debtor bar, for instance? What about Tarrant County Bar, Dallas Bar? Those kinds of things and ends of court will tell you that they're plugged in and that they're paying attention, and they're most likely will be reputable.
Yeah, which another thing you want to watch out for is high pressure sales and bankruptcies. I have been the second or third attorney on a number of bankruptcies where they walked in and they didn't really need a Chapter 13, but that's what they got sold. A Chapter 13 is more expensive than a Chapter 7. And there are reasons for choosing various kinds of chapters. But if you are pushed into a 13 because, well, it's the cheapest thing to start because you can file a Chapter 13 very little down, well, what that means is the attorney hasn't had a lot of money to work for you, and so you may not get the kind of attention you need. The people that I know that do this do a lot of bankruptcies, and they know what they're doing, but they're often moving so fast that they miss obvious red flags that'll keep them from serving you well. And then they wind up saying, why did this happen? Well, it's because it was number 1 on the Google search. Does not mean it's the person that you should go with. Visit with a few people, know what you're getting into. Let's talk about the different types of bankruptcies. People sometimes get confused. Henry Ford, Walt Disney, both had to file a Chapter 7. Chapter 7 is a liquidation process. It doesn't mean you lose everything that you own. We have these things called exemptions. Most people get to keep most of the stuff they have. For average person, loses nothing. If you have one house, you have one car per driver, you have a few dollars in the bank. But if you've got a Rembrandt on the side or you've got a collection of nice cars, that's going to be a problem. Chapter 7 is that liquidation that most people go through. Chapter 13 is a reorganization. Typically 3 to 5 years. It's for people, it's not for businesses. Chapter 13 is typically for somebody who's lost their job, now they've got a job, they've got steady income, and they're going to get caught up on a house. That's 90% of the Chapter 13s. For 7 to 13s, am I missing anything? No? Okay. And then Chapter 11s. Chapter 11 is the big one. The big one, it's by far the most expensive. It's for businesses, and it's for people who have a lot of debt. Typical Chapter 11 individual, I did one not too long ago, he had several duplexes. And so because of all of that debt associated with the duplexes, he didn't qualify for a 13, where he would ordinarily have gone. So if you have a lot of debt, you will, even as an individual, you can file an 11. Of course, every business will file an 11 or a 7.
Typically, high earners with high income often will not qualify for the Chapter 13, depending on their debt limit, and that's when you would file a Chapter 11 as an individual, is when you've got a very high income.
Right, you have to qualify for a 13, you qualify for a 7, everybody qualifies for an 11.
And I would just interject that a 7, you don't have to have a payment. That's a discharge. A 13 and an 11 is a payment plan or reorganization plan.
Right, so there's going to be, and an 11 is, you know, if 7's here and a 13's here, and 11's way up here, so there's a big difference. What you'll hear is the fresh start. That's the phrase that we always talk about. I want the fresh start. And we can provide that to you, but only if we know all the things that we need to know. So when we come back, we're going to talk about how you can, the process of going through this so that you get the fresh start at the end. So we'll be back in just a minute.
Hang on, y'all. More with Warren when we get back. Welcome back, folks. You're listening to the White Hat Law Show with Warren Norris. Take it away, Warren.
Welcome back. In this segment, we're going to talk about the process. A person has decided, I'm going to go through bankruptcy, and now I need to figure out what I'm going to do. I've visited with an attorney, and I've formed a fee agreement. I've signed on the dotted line. I have a written agreement, and now what happens? And so Annette handles most of our processing with people who come in, and she works with the forms, the magic forms. Annette, tell us about how that process works.
Well, typically they've already had a consultation with an attorney, and so then it's time for them to have a consultation with me, and we usually sit down for about 45 minutes and go over what I call the paperwork, the homework, which is usually a notebook that has to be filled out and some forms that talk about the documents that must be produced, given back to us. And so that process takes about 45 minutes to an hour. We go over some of the finer details of what they're going to have to produce, what they're going to have to disclose, which is everything. But that's also a time for us to kind of just get to know our clients. This can be a difficult time for individuals or businesses. And so I kind of get to know their story. What we try to do is to not only just file bankruptcy for someone, but walk with them through the bankruptcy. So it's a point to get organized, let them know what they need to do, let them know we're going to be there along the way with them, and then we kind of just let them go and start filling out and gathering those documents that we need. And of course, we're always there for questions.
Well, it's pretty daunting though, isn't it? About 60 pages? Are they going to have to, how long is this going to take?
Yeah, typically it is daunting. And when we first come in, we talk about that, and that's why we try to keep it as organized as possible so all of that paperwork doesn't seem a little scary.
But isn't it like, I tell people, look, there are 2 pages just for listing of real estate, right? And for most people, it's, I've got one house. But we have 2 pages for that, and it asks for, list all of your airplanes, you know, and how many goats do you have? And so, although it's 60 pages, a lot of those pages are blank.
Right,
So,
and a lot of it won't pertain to the individual. We also have different documents for businesses to disclose. I would say typically a client takes 2 to 3 weeks to gather the documents, fill them out, and get them back to us. then our process can be 2 to 3 weeks as well. So it can take about a month, give or take. Sometimes I've had people do it in a weekend when they're very ambitious, but I've also had people take a year just because they can't quite get over it. But we're with them along the way. We try to make those follow-up phone calls. Where are we? What can we do for you? That kind of thing. Keeping the communication always open, always being accessible to our clients to make sure it's not as daunting.
What about your favorite, the bare bones?
Bare bones is not my favorite. Bare bones would be there's an emergency situation. For instance, your house is being foreclosed upon or a car is being repossessed and quickly need intervention. And so we do that in a very quick manner, and we only file what is absolutely necessary. And so that might seem like a great thing, but all of that information then has to be very quickly gathered and given to us so that we can file in an appropriate, timely manner for certain things. And it can be a little bit more hectic.
I think that what Annette's trying to say is she hates those.
No, we like helping people.
We do like helping people.
And if we have to do that, we will. But we would prefer a little bit of time so that we can help you through the process, make sure that there are no other options for you besides bankruptcy. And if we know that in time, a lot of people will wait till the last minute, and they're going to have a house sold on the courtroom steps next Tuesday. If you call an attorney first and get that advice when you're having financial trouble, we can sometimes really sidestep bankruptcy if we need to, or some of those pitfalls.
Yeah, the problem is that people will sometimes have this in their brain. They're going to have this miraculous thing happen. And so somehow money's going to come in and they're going to be able to pay for that house, and it doesn't happen. And so they call us on a Friday afternoon to stop a foreclosure on Tuesday. The problem with the bare bones is that it sets up a train of deadlines, and that train of deadlines is not trivial to deal with. And so that it's when we say you want to take somewhere between 2 and 4 weeks to file a bankruptcy, that's a nice, sane process where people are relaxed and they're doing the forms while they're watching the shows, and it's just relaxed. But quite often it has to happen faster than that. And so they come in, they fill out the forms, and then what happens after you get the forms?
Yeah, so typically when they're finished, I'll always just say, just call up the law office and let me know when you're going to drop that off, and I'll look that over, make sure everything looks good, and then I start my work, putting a lot of data entry in, asking the attorneys legal issues if we need to look at different exemptions for you. You know, Texas is a great state to file bankruptcy in for Chapter 7. Most of people's possessions are exempt, but sometimes we have to really look at the exemptions, make sure we're doing that correctly, and then we just kind of finish what's called a petition. And then the petition is emailed to the client, giving them plenty of time to review it, and then typically they'll either come into our office or sign it and bring it in, actually signing the document, making any corrections that we need to correct, and then we file.
Let's talk about that signing the document. Sometimes people will give us forms, and then we send them back the document, and of course the document that we send them is a typewritten, formally put together document, and that document is dozens of pages, pretty commonly 50 to 60 pages, and people kind of zone out. Right. Okay, you're signing these things under penalty of perjury. Right. No, and we require a real signature on there, and you're supposed to pay for that. If your attorney says, "Don't worry about that," that's a problem.
It's a red flag. Yeah, I would say that I always tell our clients is that ultimately your signature is on this document. We want to make sure we have a pristine petition for our clients. And we can only do that with the information that we are given. So it's important to disclose all of the information, to tell the truth and all of the information, and then to carefully read over the petition to make sure that there's nothing left out. And so they are going to be signing that petition. So we want to make the cleanest petition possible.
And we don't want to say that if you get something wrong, you've perjured yourself. That's not the point. The point is that you just want to be as good as you can be and provide the information that's involved. So we get the petition, they sign the petition, and then we file it. And so then when you file a petition, something called the automatic stay comes into play. We love the automatic stay. It's kind of the thing that's great about bankruptcy. Automatic stay means your car doesn't get repossessed. It means the phone calls stop. It means the foreclosure stops, at least for a little while. It's that brief moment of where you can breathe and get some respite and try to figure out what you're going to do next. You decide you're going to try to keep this car. It's too much. it was okay when you had your good paying job like 2 months ago, but it's not okay now. It's a good time to give it up or to make a change. The automatic stay it's a shortened way of saying the automatic stay of collection activities. And that's what it's going to stop. It's going to stop the collections. And it gives you an opportunity to then go to the court and say, this is what I'm doing with that. It gives an opportunity for creditors to then say, okay, this is reasonable.
I would say in that process, a lot of the times, bankruptcy is a very emotional thing for anyone, again, a business or an individual. And so I typically will tell people is there's a very high anxiety making the decision to file bankruptcy. When you come into a bankruptcy attorney's office and you feel comfortable moving forward with them, the anxiety goes down a little bit. Once you get that paperwork over with, because it can be daunting, then a little more anxiety releases. Then once you turn it back in, a little bit more. Then once we actually file, even more, because as Warren said, the phone calls will stop. They'll start calling us if they need to, and you have that reprieve. After we file a bankruptcy, about 3-4 weeks later, you'll have what's called a 341 meeting of creditors. And that's a meeting typically with Chapter 7s with the trustee, and that's usually the only meeting you'll have to attend. So there's some anxiety that goes up for a 341 meeting, but again, we try to demystify it, walk you through that, and then after that 341 meeting is over, less anxiety, and then once we actually get a discharge of debt, somewhere between 90 and 120 days after we file, we can really see that fresh start you were talking about.
Yeah, let's talk about the 341 for a minute. Of course, it's always before the trustee, and it always is in a room, and it's kind of like a cattle call. There's a long group of people, and
I don't think the trustees would like you saying
well,
yes.
We'll leave that. Yeah, but you can go, and you can go early, and we often encourage people to show up early, and you can watch other people go through the 341. It's real simple. Trustee, which is just a normal person, will either ask questions, or I or your attorney will ask questions, and how did you find yourself in the situation? Are all the schedules that that we filed on your behalf, are they true and correct? It's just normal questions. It's an opportunity for people to just make sure there's no red flags. Sometimes creditors show up, but Visa doesn't show up, MasterCard doesn't show up. People who show up is what I call the X's. Ex-spouses, people who wish they were your ex-relative, ex-business partners. Those people who have a personal beef with you will show up. But 90% of the time, no one shows up. And it's 90% in my experience. And so the 341 is just the opportunity to meet the trustee, the person's just going through the paperwork to make sure there's nothing amiss. They also take a look at whether or not your payment at Chapter 13, if you're doing a Chapter 13, if that's going to be correct. And so we all come to a little kumbaya on that.
Yeah, I would say
go well.
I would say on that note that Chapter 7s and Chapter 13s are a little bit different in process from the beginning. And now towards the middle and the end, they're wildly different because you're paying out in a Chapter 13 plan. And so there's more complexity. There are more things to take care of and more instructions for the debtor. But we, again, walk with you through that and make sure that you have all the information that you need. The 341s are a little bit different, and there are more hearings and more things. You need a confirmation of your payment plan, those kinds of things. But a good attorney and a good attorney's office will give you documents that you can read over, give you instructions, and again, walk with you along the way.
There's one document I want to make sure we hit on. Do I have to have my tax returns done to file a bankruptcy?
Well, and in fact, we have filed bankruptcies with the tax returns not being done, but I can tell you trustees don't like it, the U.S. Department of Justice doesn't like it, and they are going to they're going to not close that bankruptcy.
You cannot get your discharge.
Right, and until those taxes are filed. So we really do try to get that taken care of before we enter bankruptcy, unless there's some type of emergency situation.
So yeah, the taxes have to be done. And so, and then the other issue on a Chapter 13 being the first payment. In a Chapter 13, typically you'll pay your payments monthly, and those payments will be taken out of your paycheck under normal circumstances. At the very beginning, those don't always go smoothly, and so it's very important. It's just like you're doing business with anybody. If you ever rent your house to somebody and they were late on the very first payment, you'd say, oh no, not this. And so it's a big deal to get your first payment in on time. If you don't get the first payment in on time, then you're going to get a dismissed case unless you get caught up pretty fast and we have to do some juggling. You just don't want to do that. You want to start clean, make sure your first payment is timely, And that can be a little bit confusing as to when that's due sometimes. But you don't want to be late on the first payment. It's bad voodoo. What else? At the very end, of course, after we have our 341, sometimes the 341 is continued. Let's just say right up, you got to bring your Social Security card and your driver's license to the 341.
And I think we tell everyone that about a half a dozen times.
Right.
And again, choosing a caring attorney, going through this can be a difficult process. It is important that you know that they're going to communicate with you. Contacting you not only to let you know when your 341 is going to be, but a few days before your 341, reviewing what the address is, what you need to bring, making sure that they have sent the trustee the documents that they're supposed to send the trustee before your 341 meeting. So communication is so key when you're filing bankruptcy or any legal issue, and we do try to make sure that they have not only a piece of paper to read, but they've been given verbal instruction.
Okay. So then when 341 is completed, there'll be sometimes a little dance and discussion between the trustees and the attorneys and the clients to determine what's going to happen next, and if everything's going right, then you get your discharge in somewhere between 1 and 3 months, just depending on how things are going. It can easily last longer if you have a complication, but what you're hoping for is that you're going to have that all wrapped up, and the whole thing should be 2 to 4 months if things are moving at the speed you'd like. I'm not surprised when it goes 6 months for one reason or another.
It's rare.
But it's that's kind of the way it goes. So when I come back, we're going to take another break, and we come back, we're going to talk to Clayton. We're going to talk about creditor work and Chapter 11s and all of the more fun stuff that the attorneys enjoy so much more. So we'll be back in just a minute.
Hang on, y'all. More with Warren when we get back. Welcome back, folks. You're listening to the White Hat Law Show with Warren Norrid. Take it away, Warren.
And welcome back. In this segment, we're going to talk about Chapter 11s and creditor work and all the fun things that we enjoy doing. Clayton, tell us why would I consider a Chapter 11 over something else?
Well, usually you wind up in Chapter 11 if you're an entity, some sort of business entity or an individual that doesn't qualify for any of the other chapters or wants to reorganize, and generally it's going to be because you can no longer service your short-term or long-term debts.
So give me an example of, sometimes people don't understand necessarily what it means to reorganize. What does that mean? Give me an example of that.
Generally, you're trying to restructure the debt, either in how much you're paying to the creditor or the length of time in which you pay over that amount.
Right. We had that duplex fellow that I had in the last segment. He had 6 duplexes that were in an area that had lost a lot of value. So we renegotiated the actual principal on each one of those. And you can't normally do something, of course, that good. But in this case, they could look around and see the foreclosures around there, and they all knew that we can take a big hit when this guy goes under, if he's forced to go to a 7, or we can take a smaller hit and renegotiate and be better for everybody. And so that was what wound up happening.
Yeah, and that's a good point. A lot of times Chapter 11 is used as a negotiation tool in a business in order to basically refinance the notes on these sorts of things.
Yeah, in bankruptcy generally it's a matter of that we're here because there's not enough money. But we want to stay away from liquidation because that means often everybody loses, whereas if we go to a Chapter 11, everybody can do better. You know, the goal is to make things better and recalibrate for the future. So, give me an example of it. Well, what's the difference in cost, and what kind of time am I talking about for a Chapter 11?
Well, the costs up front generally are going to be much more significant in a Chapter 11, and it's going to depend on the complexity of the case and the issues. So just to set the initial retainer, but you're going to be expecting usually at the minimum 10 grand up front.
I'm not sure I've ever done one for that much. I think that that's very low. You're being kind. Mm-hmm. So it's very common to ask for 15, 20, 25,000 for an ongoing, and it depends too, right? If it's an ongoing business where you're going to want to continue to pay your employees and take in money and spend money, then it's much more expensive than if you've got an empty business that's not doing anything.
And
right?
maybe you can speak to exactly why it's more expensive. There's just a lot more hand-holding and administrative work on the attorneys on a reporting regular basis, which is the main driver of the cost.
Right. If you have a dead business that's not ongoing, then you don't have to pay employees. And so you don't have to get permission from the court to pay those employees. You don't have an ongoing utility set of bills that have to be paid. So you don't have to get permission from the court to pay that. And so if you have an ongoing business, it's much more work than if it's not an ongoing business. So, and all that has to be done up front. Because they're what we call first-day motions, things that we're going to file in the first couple of days after we file the bankruptcy. So Chapter 11 is a big deal, but it's often just a crazy valuable tool, which is, of course, why the Rangers used it and why every other major organization around, why our president has used it several times. And so, turning away from the bankruptcy side, as far as the debtor, working for the people who owe money, let's talk about the people who are owed money. What do I do if if I've been given, somebody owes me money and I get a notice that says notice of bankruptcy, stop what you're doing, stop collecting. What do I do there?
Well, the very first thing you need to do is stop what you're doing and contact your attorney, because there's something called the automatic stay that if you are found to be violating it, you can owe quite a bit in damages. So that's the first step. And then your attorney can help you walk through what options you may have as far as if you're a secured creditor, then maybe you have collateral and maybe you have some sort of options moving to relieve the stay so that you can continue collecting.
Right. Pretty common for people who are owed money, the creditors, to file a motion for relief of stay so they can get somebody who's in bankruptcy out of their rent house or out of their office space, so they can collect the car that they're owed, or they can find some way to get some redress for the debt, or they can get the debt reaffirmed, working with the attorney who's representing the debtor. Sometimes we file these adversaries. Explain to folks what an adversary is.
Well, the adversary is basically a mini lawsuit inside the bankruptcy that's going to look like a normal lawsuit, as far as you're going to be filing a complaint, there's going to be an answer required, and you're going to go through discovery possibly, and several different kinds of motions that you would see in another federal lawsuit.
And of course, we wouldn't file this if it's just a debt that's owed. We would file this if there was fraud.
Yeah. Typically, it's going to be some sort of action or omission that is fraudulent or done with the intent to, delay, hinder, or defraud is the language that's used by the code.
Yeah, the difference is sometimes hard to understand, but let's say I was going to come mow your yard, and you were going to pay me money, and you paid me the money up front, and then my lawnmower broke, so I couldn't mow the yard. Well, that's a breach of contract, and if I filed bankruptcy, then that'd be wiped away. But if I took the money, you paid me on Monday, and I just said, I'm really not ever going to, I just wanted the money to go on my vacation. Yeah. I don't have a lawnmower. I never intended to mow the lawn. I'm going to go to Las Vegas on this money. Mm-hmm. That's fraud, right? And so fraud is not dischargeable, but you have to file the lawsuit, and you have to go through those steps, and it's not trivial in a bankruptcy, because bankruptcy is designed to help the debtor, the poor but unfortunate debtor, to escape the debt or have it discharged. So there's a difference between breach of contract, which doesn't necessarily have a moral component to it, as opposed to a fraud, which has a misrepresentation, which has an element of immoral behavior and misrepresentation.
And which can be very difficult in most bankruptcies to show that to the court.
Right.
Which is what makes, I think, it's definitely possible. I've seen it happen. I've defended against it. But it is not something that it's going to be proved by usually circumstantial evidence and putting people on the stand and letting the bankruptcy judge determine, who's telling the truth.
There are lots of good stories that we all have on those, but it probably shouldn't be on the air. What happens if I'm a vendor to a store that's closed, and I get a love note from an attorney that says, send us back the money that you paid, that you received from the now bankrupt debtor, with these clawbacks? What you'll see sometimes is if you've done work for somebody, you've been paid, and then the person who paid you files bankruptcy, and then the bankruptcy court says, well, this person got paid, and these other people did not get paid, so we're going to take this money back, and we're going to distribute it out to everybody. It's very frustrating. If you are a vendor in that shoes, I feel sorry for those guys. It's almost like you want to warn everybody who's doing work for somebody who's iffy. Don't spend that money for a while. It can be iffy. So that's one of those other places where you really want to get an attorney. If you've gotten one of those notices, you really want to contact an attorney who can try to negotiate you keeping that money or a portion of the money or find out what your defenses are. What else am I missing?
The different types of claims that you may have in a bankruptcy, they're going to be, secured. It's going to be you'd want to be secured if you can, or even better yet, priority or unsecured. They're all treated differently. For the most part, secured claims get paid the value of the collateral at the very least, and then whatever portion is left over would be unsecured and may or may not get paid. Priority debts such as tax debts and domestic support obligations, those have to be paid in full. And then if you're unsecured, then you're going to have to rely on the creativity of your bankruptcy attorney to determine exactly how much you're going to get paid out of it.
Yeah, and this is generally true in all bankruptcies. All bankruptcies have claims. Creditors will file claims. Spouses will file domestic support obligations, which have to be get paid. Some taxes are secured. If there's a lien, some taxes are not secured, right? Student loans don't get discharged generally, but they're not secured, which can cause some complications too.
The one other thing I would say for creditors is to make sure that you get a claim filed in timely if you want to participate in distributions from the trustee or if you want to take part in the plan.
Right. So I hope that we haven't overwhelmed anybody, but the basic gist of this is if you're involved in a bankruptcy, certainly in a Chapter 11, you want to call somebody that is part of the bar, the bankruptcy bar, that participates routinely in bankruptcy matters, and you want to do it sooner rather than later. And if you are a business, it's how often does somebody come to us 6 months too late? Come see us before you get into that trouble, and we can help you prepare for it so that it's going to be easy. Sometimes you can put together a package deal. Sometimes you can avoid bankruptcy completely by just explaining. I did this not too long ago. I sent an entire Chapter 11 petition to a creditor and said, you're really the only guy that's causing this. We can work something out. And they said, amen, brother, let's do this. Let's work this out. Bankruptcy is not always the answer it's not the best answer to a problem that can be solved by bankruptcy. It's just a possibility. And most lenders don't want to do that because chasing somebody in bankruptcy is expensive, it's not any fun, and then the bankruptcy court has to get involved and they have to approve every little thing. It's a mess. So with that mess, we'd like to help you. Stay tuned to next time, and until then, thanks for joining us from White Hat Law.